And before we start the case, I wanted to just address both counsel briefly. You've got 9 issues, more including subparts, and I assume that in the time we have, you're probably not going to be able to address all of those issues. We've sort of met briefly and are going to request that you make sure that you cover the issues relating to the valuation of the surgery center and then the equitable distribution issues. We're certainly not going to restrict you on what you can talk about. You can talk about all the issues, but we want to make sure that you cover those items in particular and that they don't get stinted. All right. Ms. Green?
Your Honor.
Did you want to waive it or reserve any time for?
Yes, I would. If I may ask, there's a cross appeal. So normally I was considering saying I would ask for 10 minutes, do my part, and then, but I understand sometimes the courts want me to do both parts before. So if you can give me direction, I'm happy to obey anything.
Well, I would give opposing counsel, you want to reserve any time for rebuttal on your cross appeal?
Your Honor, I was thinking to reserve just 10 minutes on all of it. Maybe we could argue the main appeal and the cross appeal at the same time, each side, and then reserve 10 minutes on rebuttal for each side,
Okay.
which might give us a chance to deal with it easily and all at one time.
All right, well, let me see if I understand. Okay, you don't agree to that, Ms. Green? Or
If I understand correctly, then in my 10 minutes I will do my argument plus my response to your cross appeal that you haven't argued yet. Okay, I can do that.
and then
I'll reserve 10 minutes.
yeah,
That would be what I propose, Judge.
I'm not sure I understand. Let me. How is this going to work then?
I don't know.
She would make her argument on her main appeal and respond to the cross appeal issues that we've raised, and then she would reserve some time for her rebuttal. I would then stand up and do the reply to her main appeal issues and the cross appeal issues, and then reserve some time at the conclusion.
All right, then.
I could do that. Unfortunately, I don't know, because we're limited. I'll address the issues on cross appeal. I don't know which ones he's going to argue particularly, but I'm happy to do it that way. Anything the court wants, I can do.
Obviously, anything the court wants to do is fine with us.
Well, it appears there's not clear on how much time each side's going to have, because you all are talking about how you're going to argue and what your rebuttal is going to be. It appears from what I've heard, you're already thinking you have 30 minutes aside. 20 minutes for your first argument, 10 minutes for a rebuttal. That's what I've heard.
No, I was thinking 10 and 10.
Okay.
I understand we're
Okay.
20, so.
All right.
In light of the court's last statement that to concentrate on the surgery center and the equitable distribution issues, then we can even fine-tune that even more for the 10 minutes that we have.
All right, so then Ms. Green, you'll do 10 minutes. Then, I'm sorry, sir.
Mr.
Mr.
Severio?
Mr. Severio, you'll do 10 minutes, and then 10 and 10. Is that right?
10, 10, 10, 10? Yeah, okay.
All right. All right, then let's start then.
We'll start.
I'll let you know at the end of 10 minutes.
Okay.
I'm sorry, I didn't catch the last
10, 10, 10, 10.
That'd be fine.
All right, good.
Fortunately, those are numbers I can handle. May it please the court, my name is Cynthia Green. I'm representing the former wife in this case, along with co-counsel Christopher Lombardo. And based on what we've just said, we know that we have raised 5 points on appeal. I would like to begin with what I think is the most global of all of the issues today, which are the glaring deficiencies in both the final judgment and the order on attorney's fees, which we submit renders both of those orders reversible as a matter of law. The final judgment, as the court knows, awards permanent alimony to the wife and mentions, as findings of fact, only 3 things. It mentions the length of the marriage, the parties' ages, and their educational history. all of the other required statutory findings with respect to alimony awards are absent. There's no mention of standard of living, there's no mention of financial resources, earning capacity, contribution to the marriage, sources of income. There's not a word anywhere in that judgment. In fact,
Do I not, when I read the brief, so did I misunderstand, or did Judge Starnes present to you his rough draft and said, look, this is what I have, tell me what needs to be changed or corrected? Okay, because it was argued that that occurred. Did that not occur?
that did not occur. My understanding, and remember, I was not...
The only time you ever saw his judgment is when it was rendered in its final form?
I'm deferring to my co-counsel who was the trial counsel. I understand there was a hearing that took place after the trial where the judge brought the attorneys in and said, this is what I'm thinking. There was no writing followed that, and in fact...
That was the December hearing?
Yes.
Right.
The argument, I believe my understanding, I was not there, so I'll defer to Mr. Lombardo, Ms. Hall, Mr. Solerio. The attorneys couldn't argue. It was just, this is what I'm thinking of doing on certain issues. There was no writing from that at all. So I am unaware, and again, as I said, I'll defer to Mr. Lombardo, who's shaking his head no, of any judgment that everybody got to see before it was signed or anything like that.
Okay.
I am not aware of that.
After the first written document, there remained the invitation to alert the court as to any problems with it.
That is correct, and that...
both sides made use of that invitation.
Yes, and as you know, because it was mentioned in the answer brief, I believe, there was a 200 and something paragraph motion for rehearing filed on behalf of the former wife, which raised everything that I'm saying
Well,
here
let me ask you this, Ms. Green. The wife's not challenging the amount of the alimony. Husband's not challenging his ability to pay. It's certainly obvious that the husband is doing extremely well.
Well, the husband's challenging the amount of the alimony.
Well,
It's one of his issues on
he's not
cross-appeal.
challenging his ability to pay.
No.
You're not challenging the amount. So what difference does it make?
I'm not challenging the amount as it stands today. However, on cross-appeal, they have argued that the amount is excessive. They're seeking to set aside the amount of the alimony award. And that is why the absence of findings of fact become critical, considering they raised that as an issue on their cross-appeal.
But isn't their main issue about what income should be imputed to her?
That too.
Okay.
That more income should have been imputed to her. That the amount is erroneous because on the alimony, you're right. If nobody's challenging the alimony award, which we're not, but if nobody's challenging the alimony award, you're right that those findings that I just mentioned are missing are not relevant. But my understanding is they are challenging the alimony award, at least to the extent that they claim. And in our brief, we actually had to write that it's supported by the evidence. The amount was, in fact, supported.
Their challenge isn't based on his income or ability to pay.
It is not. It is not. His income, by the way, is not even a finding of fact in the judgment. The only place you find his income is it's on a line in an attached child support guideline. So there aren't even any findings about his income, which is an issue in this case, to the extent that what the trial court did or did not consider as being parts of his income, including corporate distributions. So, and that is highly relevant to child support, because the amount that was used in the guidelines is the $128,600 whatever per month, when in fact that does not include corporate distributions to him. They made it clear that that was a taxable figure of just what the salary is, not anything else that he gets. And for child support purposes, that's erroneous. And so the findings as to income are very critical to child support, and there is a minor child who I think is about 5 or 6 now. So those findings are necessary as to the child support. But you're right about the alimony if they're not challenging it, but in fact they are. But that takes me to the attorney's fee order, which is even more deficient. There are absolutely no row findings as to reasonable hours expended at all. The trial judge, and you know this, decided that representing the non-moneyed spouse costs 15% more than representing the spouse with money. And that was the entire basis for the determination of the fee award here. Now, I know in their brief they write, yes, there are row findings, but actually what they put in their brief as row findings are the factors from the old Florida bar rule, not Roe. Roe is lodestar. How many hours, reasonable times, a reasonable hourly rate? There is absolutely no finding of that in this final judgment. And the invention of this 15% criteria finds no support in any law that I'm aware of. And the wife, as a result of that, was shortchanged significantly in the amount of fees awarded to her. And although I'm not arguing the fee point right now, I'm arguing the deficiency in the judgment. I would point out that the husband's expert witness testified that $400,000 would have been a reasonable fee in this case. So the evidence of that amount coming from that side, when the fee award was based on a 15% increase from the husband's fees. And what's really disturbing about that is so were the costs. Now, if you have the non-moneyed side, you need an accountant. The moneyed side just brings in their accountant. So obviously, it's more than 15%. The non-moneyed side of the case, male or female, is always more expensive to litigate in terms of what kind of expert witnesses you need. So I don't know of any authority for the basis of this attorney's fee award. Now, I want to go to the value.
He explained quite clearly that he thought there was a lot of wasted time.
He did explain that there was a lot of wasted time, but then again, you have to counter that with the husband's own expert witness saying that the amount of fees that were actually generated were reasonable.
Remind me, Jim, what was the total?
I'm sorry?
What was your total?
I was 423.
That included cost?
No,
Those fees?
that was fees. That was
His
fees.
expert said what?
400. And the award is 350 because it's 15% over. No. Now, I know that I certainly did read that the trial judge found there was a lot of wasted time, but I do need to point out that there were difficulties in this case that were unusual to this case. And because of who the parties were. The husband is with a medical practice that apparently is employed or used by virtually every judge in Collier County. That was the reason for 8 disqualifications on their own motion, half of them, or more than half. Every trial judge that this case was assigned to went to that particular medical practice. And ultimately, so a hearing was scheduled, you were going to have a fee hearing, you were going to do this, the disqualification came in, it's a start over. Start over, start over, start over. Then you know, because it was in a...
Criticisms of Judge Starn were not related to that, they were related to the manner in which the parties did or did not make efforts to streamline the process and to engage in efforts to narrow the issues and perhaps resolve the case. That were the criticisms of Judge Starn's.
And I do understand, and I do know that, but I also think that the record doesn't necessarily support that. I think, for example, they were able to streamline most of the children's issues, custody issues, time sharing were streamlined. But when there are unending discovery issues, when there is an inability to actually get hearings because not nobody's fault, certainly not the fault over on this side of the room, but the constant disqualification of the judges because of this particular medical practice having such a significant impact on the male judiciary in Collier County.
So the 8 judges were all male? Or we couldn't find a female down there to do this case?
It's the type of medicine is kind of specific to men.
No, I understand that, but I mean, there's a lot of women judges on the
I don't think
bench.
we ever got assigned
I mean,
one.
we just happened to draw 8 in a row that were men? That's just, the odds of that are low.
The female judge was married to a doctor that was connected.
I feel a little better about that.
Yeah. But so I know I certainly read it and I certainly know what Judge Starnes believed, but I honestly don't think that there was any particular evidence that supported that, given that the husband's own expert witness said that $400,000 on the wife's side is reasonable. The wife's $423. So is it $23,000 was because they weren't cooperating? I just don't see it that way. But I think that in fairness, what obviously should have been done is there should have been a lodestar. And if there was a belief on the part of the judge that certain monies were expended that shouldn't have been, that comes off the lodestar. And that's not how it was done here. This just 15% across the board number was applied, and I don't find any support for that anywhere in the law.
All right,
So-
Ms. Green, at this point, you're at 10.5 minutes. So
Oh. All right, well, let me take 4 more, and then I'll only leave 5 for myself on the rebuttal. I want to talk about the valuation issues, obviously. we know that in 2005, the husband bought into the medical practice, and there were 3 components to that buy-in. The PA itself, his buy-in of a 25%, cost $1.9 million. It was 1.877, call it 1.9. The same time he bought 25% interest in the surgical center, that was $458,000, and he bought a 25% interest in the building partnership for like $688, call that 7. The trial court valued the husband's interest in the PA at $431,000 when he had paid 1.9 for it, and reduced that from 505 because he's going to have to pay capital gains sometime in the future if he ever sells it. So at a minimum, the 431 was unsupported by the evidence. It's speculative. The worst case scenario was 505. The surgical center is the real issue now. I'm not going to...
Well, I think the surgical center is the only one that you really challenged in your brief, right?
Yeah.
I have a question I want to ask you about that. There seems to have been a big issue about goodwill, present or not present in the evaluation of the surgical center, and the cases that are cited that that you should exclude goodwill from this calculation, and what basically the trial court and the husband's expert used to come up with a net asset value of 0, basically say that in a professional practice you don't value the goodwill. But those cases all deal with personal, professional practices like a law practice or a dental practice or a veterinary practice, not with a freestanding entity like a surgical center. So how
that is correct.
Valuable are those cases to our inquiry here?
They're not. And there's one reason, one overarching reason why they're not valuable at all, which is there are no covenants not to compete from these 4 doctors. The junior doctors are required to sign it. The senior doctors, the 4 that own the center, have never signed a covenant not to compete. They can walk out the door tomorrow and open across the street. And that, if you flip the case law, is proof that there is no personal goodwill. The doctors do not have to, the surgical center is not limited to only these doctors or this practice operating there. The doctors get their share, their 25% share, whether they do 1 surgery there or 10,000 surgeries there. They get their share every month. And I think the most telling testimony was when the accountant for the husband was asked, well, wait a minute, you're valuing this at 0. So are you telling this court that someone would pay 0 for an interest today and get $253,000 in distributions within the next 6 months? And the accountant answered, yeah, pretty good deal, huh? That's the answer.
Is there any case law or other authority that you can point us to that would differentiate the entity like a surgery center from a straight professional practice?
None that I'm aware of, but I think that the cases that were cited do that by virtue of talking about the existence of a covenant not to compete, or, for example, the Held case, which was it was an insurance practice, but what was the contract? It wasn't a covenant not to compete. It was a non-solicitation, which they said was the equivalent. These guys have none of that. There's no covenant not to compete. There's no non-solicitation. There's no prohibition on them walking out the door, opening a surgical center across the street. There's not even a requirement that they do their surgeries there if they don't want to. They can do none and get their share. So it is an investment to them. And it is the same as any other investment that's paying interest.
Is it an investment, or is it a vehicle to generate an income stream to get around the Starnes regulations?
It is. It is. It's essentially, all it is an income stream. It's a non-ending constant income stream that they do not necessarily have to even work at to get the income stream. They just have to own it. Now, and I think that part of the thing that was very, very interesting was the evidence presented below about what was being paid to buy into that entity at the very time that the trial was going forward. There's 3 other doctors that bought in, and the price that was paid when the husband's share went from 25% to 1/7. So he got paid for that difference because they liquidated his share a bit. They diluted it. The price that he got paid converted up to show that the value of his 25% interest would have been $977,000, which was right in line with the testimony of the wife's expert witness, that that was the value of the company. Excuse me, Judge Starnes test that said, I find it as a zero value because it doesn't have, because its net assets are zero. Well, of course they are. They liquidate it out by distributing all the funds to the 4 owners. Now 7 owners, but at the time 4 owners. That's why it comes to a zero at the bottom. But
Ms. Green, you're
I'm done.
Past your 5 minutes now, so
I apologize.
that's okay.
I'm done.
All right, Mr. Silverio.
Please, the court. I'd like to save a couple of minutes for my partner, Ms. Hall, to argue on the alimony issues, on the income issues. I know that the court wants to focus in on the equitable distribution, but I'd like to have her 2 minutes of my 10, so I'll go 8, and I'll try to go quickly through the 8 minutes. As I understand, the court's concerned about
4 issues relative to
equitable distribution. The house awarded to the wife, surgery center valuation, post-filing income that the court split 50-50, which was an equitable distribution issue on the wife's side, and the $750,000 that was not included on the equitable distribution sheet, which was a marital liability. I can deal with the house very quickly. The house was awarded to the wife, where she was principally residing in it during the pendency of the case with the minor children. It was valued by an appraisal, and it was awarded to her with debt on it, but the debt was ordered to be paid by the husband within 1 year. So they didn't get a house with negative value. They got a house which was awarded to her based on an appraised value, with the husband paying all the debt.
What do you make
pay
of
off half and then transfer the lien somewhere else,
And
right?
that's what happened.
what do you make of the Chavez case that's cited by Ms. Green?
The Chavez case about
That's a case that said if you even though the husband or the paying spouse is ordered to pay the mortgage, you still have to assign it at a net equity value.
I don't think it applies to this case. It clearly was stipulated right from the get-go, the early part of the case, we stipulated that she would get a house debt-free, that he would pay all the payments, which were interest payments only, and that he would pay off that principal, the $1.4 million. So in effect, you just can't look at the snapshot at the time of the filing. You have to look at what happened with respect to that debt. And she got a home debt-free. 2, the surgery center. Not only did the husband's valuation, the wife's valuation, include personal goodwill, but it also was violative of the double dip rule. He used a discounted cash flow method in order to value that surgery center. And he used the same income, the future discounted earnings, which was used to determine the alimony and child support. That is fatal in and of itself. We believe that the cases that talk about personal goodwill in the context of a closely held entity, and this surgery center is a closely held entity, has personal goodwill. What the doctor bought, when he bought into that, was an income stream. And that income stream was the product of his personal work efforts. And when they valued it, if you put in a discounted earnings, you are necessarily capturing his personal goodwill.
I mean, if you value the thing at 0, and no one ever sold for 0, no one ever bought for 0, and people were paying hundreds of thousands of dollars to buy a fractional interest in this entity, how do you support a 0 valuation?
Because I think in the context of valuing closely held companies or businesses in divorce cases, you must follow those case law, which says that it's not necessarily what somebody paid for it, it's what it's worth for purposes of an equitable distribution. And oftentimes people write about that the non-moneyed spouse gets a short end of the stick in the valuation in a context of a divorce case. And unfortunately, it's not what people paid for it, it's how it's valued here. And in the context of a equitable distribution in a divorce case, you must take out personal goodwill.
Okay, well, let me ask you the question that I asked Ms. Green. I mean, the cases, all the cases that you cited related to, on this issue, related to professional practices, where it was, the dental practice, the law practice, the medical practice, the veterinary practice, whatever. None of those cases dealt with a freestanding entity where the income stream is not necessarily related to the professional's efforts. So how are those cases decisive or controlling here?
I think they are. The one case that we did cite, which we supplemented, is the Schmid case, and that case is a retail optical business. In that case, the court pulled out personal goodwill out of that retail optical business. The other cases are doctors and practitioners. But the Thompson case clearly sort of sets the tone as to how you value work ethics and work efforts of a spouse in the context here.
Well, let me ask you this, just hypothetically, let's suppose, God forbid, something happened to Dr. D'Angelo and he wasn't able to perform surgeries at the surgery center. Wouldn't he continue to get paid?
It's not sure. There's no testimony in the record below that he would still get paid with respect to that. There's no evidence that he would have. There's evidence that had he left, he would have taken his business with him. And what counsel seemed to argue about the absence of a non-compete, she's got it totally reversed. The absence of a non-compete is evidence of personal goodwill. It's not the absence of a non-compete is evidence of no personal goodwill. That's exactly what Held and all the cases say. If there's no covenant not to compete, Dr. D'Angelo can take and open up his own surgery center and take all of his patients with him and earn all of his income with him. And that's personal goodwill. Besides, we can't overlook this double.
The center is no different than your retail optical situation. It's got hard assets. It has debt.
And this has hard assets and debt.
And debt, and you subtract it.
That's how we got to zero here. And unfortunately, maybe that's not a number that smacks is a fair number. But it's what the law says. You must apply this adjusted book value number. This is what all these cases apply to the valuations.
The shareholder agreements provide for the buy-in into the surgical center. Is that correct?
I think so, yes.
But no one valued it using a formula where someone would buy in or have his...
No one valued it under that basis. What the husband's valuation, it's just what the record shows here. The husband's valuation was a discounted cash flow method, which clearly not only double dips the income, but I submit captures personal goodwill. Two other quick points I like to make. The court committed error, we submit, on our cross-appeal issue, on the dividing this post-filing income 50-50. He took $267,000 of income that came into the husband post-filing from various sources. Clearly it was income, not dividends and not an asset, and he divided it and gave her half. And we submit cases, and even the court said that there was some very fuzzy legal reasoning that he had to get this done. We think that's error on our cross-appeal. We also think that the omission of the $750,000 debt, which was part of the debt on the home, made up of the $1.4 million debt, that should have been a marital obligation. reflected on the equitable distribution sheet. And that was not placed there. That was taken off. And I submit
You're
that's it.
beyond your 8 minutes, if you want to save 2 for co-counsel.
One last point I'd like to make on the fees, because counsel keeps harping on the fact that there's no lodestar calculation by Judge Starnes. That's just not correct. If you look in the order awarding the fees, he makes it clear. He calculates the number of hours, he calculates the number of the hourly rate of the lawyers and the paralegal, and he comes up with a lodestar of $460,000. And then he makes adjustments off of that, based on the factors in row, where he can make adjustments by looking at all the circumstances. So we submit his attorney's fee award was proper.
Good morning. I'm going to address primarily the alimony issue. You are correct, the court's correct, that at all times the husband conceded this was a permanent alimony case based on his income stream and based on the length of the marriage. But as we said in our brief, he didn't mean to tender a blank check to the court to give the wife whatever amount she sought. Her first financial affidavit stated she had $43,000 a month in expenses. Absolutely impossible. Her second financial affidavit said that her monthly expenses were $33,000. Again, absolutely impossible. And throughout the brief, we did the exact same calculations that we gave the court with regard to the possible source of income for the entire family's spending in the year of 2007, which was the last full year of the marriage. We demonstrated with no rebuttal whatsoever from the wife that the parties had a joint bank account.
Well, wasn't there some kind of a schedule or something submitted by the wife's expert, Gail Markham, that came up with a figure about a net of what the wife needed of $17,900? Isn't that evidence to support what the he came to the $24,000, which tax adjusted resulted in like $18,000 for her, which was real close to the wife's expert's number.
That's not the exact number. What happened is, and I could look it up for you, but the schedule that the wife's expert prepared was higher than that, and then Judge Starnes in court made some oral adjustments that he would make. So when Ms. Markham made the oral adjustments to that schedule, it came down to the $17,000 number the court's recalling that's mentioned in the brief. And so at no time did Ms. Markham present that $17,000 or $18,000 number as the need. It was significantly higher, but Judge Starnes was able to pick apart and deduct some of the expenses. But
so why isn't that competent, substantial evidence that supports what the trial court did on the alimony award for the wife?
Well, it was an impossibility based on the amount of money available to the family in 2007. And if you read carefully the cross-examination of Ms. Markham, she had to acknowledge that we were correct. She tried to scoot around it. For example, when asked about the salary of the husband, she said, well, she didn't know. And yet the trial record shows that during the trial she asked for documentation with regard to the payroll. And when she was walked through all the steps of the money that the family of 5 had available, her number on need fell apart. In addition to that, we were able to demonstrate that Ms. Markham incorporated extraordinary expenses. It was unrebutted testimony that Dr. D'Angelo and his wife made several attempts to reconcile their marriage. They took 3 expensive trips in the year in 2007 in an attempt to salvage their marriage. A couple of trips themselves and 1 big trip for the entire family to Hawaii. All those expenses were captured in Ms. Markham's analysis. In addition to that, they testified that there was some extraordinary spending on clothing. There was a long portion of the transcript on that particular issue, that immediately before the trips there were some expensive purchases that had not been historically correct. And Ms. D'Angelo acknowledged that her husband had asked her to return some of the items. All of those huge clothing expenses were included in Ms. Markham's. In addition to that, once the divorce was filed, which was in October of 2007, Ms. D'Angelo went out and did all new landscaping for the marital residence, a home that she wanted to retain during the marriage. She replaced all the appliances. She replaced the computers. All of those extraordinary expenses went into this budget Ms. Markham had for 2007. In addition to that, Ms. D'Angelo had to acknowledge that she surreptitiously was taking money from the joint bank account. Dr. D'Angelo had put school tuition on an automatic pay. She went in and unilaterally took it off so that the children's private school tuition was not being paid, and spent more money in those months when the marriage was falling apart and the divorce was actually filed. In addition to that, in 2007, Dr. D'Angelo had his own personal housing expenses and living expenses in a separate home, which were included in Ms. Markham's budget in 2007. So there were extraordinary expenses. We demonstrated them down dollar by dollar through this record. We showed that the amount of money that the family had available for a family of 5 was between $24,000 and $26,000 a month for this entire family. Private school tuition, a lot of expenses that would not be reoccurring were included in those expenditures in 2007. So it's not supported by the record here. We do believe that the court made findings of fact. There were findings that were attached to the final judgment. The court is absolutely correct. On at least 2 occasions, Judge Starnes invited the attorneys to assist him on any deficiencies the attorneys felt that there were in the final judgment. One of them was findings. We went back on the rehearing and adopted multi-page findings made by the judge, typed himself, which incorporated contributions to the marriage, the education of the parties, the employment history of the family, in addition to the other ones that made it into the final judgment. On the imputation of income...
Ms. Hall, just, continue if you wish, but you're way beyond your 2 minutes.
I'd rather Mr. Silveria have the time to address the court's issues. I think the imputation of income is well set out in the briefs. Thank you.
All right.
May it please the court, Chris Lombardo, counsel for the former wife, and I was trial counsel as well.
Just for housekeeping, do you still want to, you've got about 5 minutes left, so.
I'm going to try to keep it to the 5 minutes. I'm going to do my darndest.
All right, well, you use up your 5 minutes then, so you wouldn't have any rebuttal.
Well,
okay.
I understand.
All right.
I want to focus our attention on the surgery center because I think that is the most glaring error in this circumstance. We have to recognize the surgery center is a facility. It's not like a practice, like the professional practice, the practice itself. We had that as well. The surgery center was a facility. It was an investment that the doctors made. And recall that Dr. D'Angelo was not one of the original principals.
Help me with that. That seems like you're working hard to make a distinction without any real difference. So why is a surgery center any different than any group of professionals who are working together and generating income?
Right, because the difference is essentially this. The surgery center is like a small hospital. The practice is a collection of professionals, and they have the ability to do an eat what you kill approach. That's not how a surgery center works. Under the Stark regulations, in fact, that's what limits them. So they become shareholders, equal shareholders. And by the time Dr. D'Angelo buys in, and recall that he purchased his interest, paid over $490,000 for it, he buys at 25% interest. The telltale facts that make you see the difference in this situation, and in particular that this is not a personal goodwill issue, is the fact that we divide the profit equally, 25% each, meaning he's a shareholder. If he should pass, if for some reason he is no longer able to perform, he's still a shareholder. He's still entitled to his percentage of the profit.
But the reputation of each doctor who's an owner of the surgery center certainly has an impact on the people that elect to use it. And
well, no, because
it's
the
very essence of what goodwill is.
Well, but that's not what's happening. The surgery center is about that doctor making the choice to have the surgery performed there as opposed to at some other facility. And so the surgery center is not a reputation-based facility. The fact is...
It would be for me.
Well, no, because your doctor is making the choice as to what facility to use. Look at it this way. The husband argues that he produced 150% more in the revenue at the surgery center than the other doctors. Well, then ask yourself this, why would he accept 25% of the profit, the same amount the other 3 partners did? When the sale occurs, which occurs during the first week of trial, the 3 new partners that buy in pay based upon the value that's very, very close to what Mr. Schultz did. By the way, the question was asked before, did anybody look at the shareholders' agreements and the historical practice of how buys and sells occurred in that practice? Dave Schultz did exactly that. That's how he came to the value. And so when you look what happens, and this is a curious circumstance, these three new partners buy in and pay the net equivalent of $971,000, which would be the value of Dr. D'Angelo's interest. And yet, when we go from 4 partners to 7 partners, we wind up with a distribution of $20,000 per month per doctor, just like it was when it was $20,000, when it was 4 partners. And so you ask yourself,
For accounting purposes, how is that booked? Is that a dividend payment?
yes, it is a dividend payment. It's a dividend payment because it is not a performance base, and it can't be because of Stark regulations. And that's why, and so you look at it from what's the law? The law is not, we must use a net adjusted book value. The law is fair market value. What a willing buyer would pay and what a willing seller would sell for. A willing buyer would certainly pay 0 to get an income stream of $240,000. A willing seller is not going to sell for 0, and as evidenced by the fact that Dr. D'Angelo himself did not say to these 3 new partners, just come in, because the admission of these new partners is going to improve the revenue, and we're all taking our pro rata share of what we produce. That's not what was happening. We're getting equal division.
I'm going to be willing to pay 0 if I know Dr. D'Angelo. I can't anticipate that cash flow.
Well, and here's what I would expect, Judge. If you say to yourself, all right, this is Dr. D'Angelo's further involvement is critical to my investment, and that's what you're saying, and I hear you, then what you want is a covenant not to compete. That's not what they got. All 3 new buyers, just like Dr. D'Angelo, bought without a covenant not to compete. And that's where the confusion arises. What you were told today is the law is the absence of a covenant not to compete is indicative of personal goodwill. That is not correct. That is a misstatement of the law. The existence of a covenant not to compete is indicative of personal goodwill. The absence, actually we have no case law that specifically says, you have to say, all right, what's the corollary to that? Why is the covenant not to compete evidence of personal goodwill? Because a buyer isn't going to buy if he's worried that the doctor's reputation is what's driving the revenue and the doctor is going to leave and go across the street and compete. So you would want a covenant not to compete. When you look at all of the cases they cited, Young, Walton, Thompson, even Chinook, it's one practitioner. It's a one doctor show or a one insurance agent show in the Held case. I mean, by the way, the distinction in Held was nothing more than a non-solicitation agreement is exactly the same as a covenant not to compete for family law purposes.
It's Lombardo, you need to wrap up now, sir.
So at the conclusion of this, what we need to recognize is the court shortchanged the wife by accepting a 0 value, particularly in light of the fact that we had an actual transaction that demonstrated unequivocally that that interest was worth $971,000. I just want to add one other point. The comment with regard to alimony and this whole debate over the findings, I think, is indicative of the fact and demonstrates the fact that the court did not make findings of fact. And so I find it interesting that the husband would take the position that the final judgment does not have errors, but then turn right around and tell us that there are valuation problems, that there's a problem with the way the house was treated, there's a problem with the way $750,000 was treated, and there's a problem with the way alimony was calculated. All indicative of an overall problem globally with the final judgment. Thank you for your time.
Sir. All right, Mr. Silverio, I'll give you 5 minutes.
A couple of statements that I think need to be corrected. Number one, both counsel have argued here that the buy-in by the new doctors that came in during the pendency of the trial is somehow relevant to this. The court excluded that testimony. They never appealed that issue, that the valuations of those transactions which occurred after the date of filing were not to be considered for purposes of valuing any assets, particularly the PA. They never challenged the value of the PA. They never challenged the value that the cancer centers, which generated income with which the new doctors bought into, were non-marital assets. They never challenged that. The only equitable distribution valuation issue that they've ever challenged is the surgery center. That's the only issue that we're talking about here. And when you look at that again, the fact of the matter, as Your Honors have indicated, it's Dr. D'Angelo's reputation. He has produced the income. Since he doesn't have a non-compete, he could go to another facility, set up another surgery center, and generate that income and keep it. The surgery center only has income as a result of the products of the doctor's work efforts. That's what generates it. How they split it up is irrelevant. How it is generated is the key.
Isn't it, and the existence or non-existence of a non-compete can be for many different reasons, one of which was they just said, we don't want them.
That's right, and that's what they said. They didn't want them. None of the 4 founding members of this practice, this specialist in urology, ever had a non-compete. None of them. The new doctors that came in had non-competes. So there's no restriction here for any of them to leave, including Dr. D'Angelo, which is an important factor here when the court has to value this surgery center. And secondly, I want to stress that
His motivation to stay, however, is based, I guess, on the debt on the center. Is that clear?
He's obligated on that debt. Also, it's a personal decision whether you leave or stay in terms of who you're practicing with and the quality of your partners in terms of the practice. But this particular surgery center had $25 million worth of debt. I think that was the number. It's reflected in Mr. Cohen's report, which created the negative value here. So I think that you have to look at the evidence in the record here. And I believe that there's no legal difference because it's a surgery center as opposed to a PA with a doctor practicing himself. So I think those cases are applicable.
Well, let me ask you the question I asked Ms. Green. Do you have a surgery center case or something like that?
I don't have a surgery center case. The cases I do have, on some of them, are cases that deal with widgets, I would say, with businesses who have, there's a business around here that, such as Griffith, and there's an author who had a book company where he was making his books and writing his books. That case, but no case specifically on a surgery center. But I don't think you need one to look at the case law that started in Thompson and went through the series of all of these decisions. It's based on the reputation of the husband who's producing the income.
Let's suppose a hospital or something like that, we're going to buy the surgery center, all of it or a percentage of it. Would they sell it for zero to the hospital?
I think they probably wouldn't, but that's not the test for valuation for equitable distribution purposes. There are many cases that talk about when somebody wants to sell a business for $10 million, but what's it worth when it's being evaluated for equitable distribution purposes? Unfortunately, that's a different number, oftentimes less, because of the clear indication in these case law that you must exclude out of that $10 million number what the personal goodwill is of the particular spouse who's getting divorced. That's the difference there. And that's why the comparison of what he paid and bought it in for and what it would sell for are not necessarily the relevant analysis. I agree that it's a willing seller and a willing buyer, yes, but the courts have imposed a condition on that, and that is, it's not necessarily what a willing buyer and a willing seller will do. You must exclude out of it the classic personal goodwill, as opposed to enterprise goodwill, which clearly would represent that $10 million purchase price that I...
All right, Mr. Severio, you've exhausted your time at this point, so you need to wrap up as well.
Your Honor asked a question about was it a dividend or whether it was income. Under the definition of income, under Chapter 61, dividends are income. And so that whether it's a dividend a return of investment, as they argue, or income as a distribution, it doesn't make any difference. It's the same under the case law and the statute. Thank you.
All right, thank you both. Very interesting. Presentations were helpful. All right, the next case will be Battle versus State.